Good morning. Welcome to the Board of Zoning Appeals. Before we get started with our first case this morning, Mr. Dixon's going to read letters, requests for extensions.
All right, we have a request for an extension in case 6515 by Matthew Luzuriaga. The approved use is currently the subject of a petition for judicial review, circuit court case. At the present, the matter is scheduled to be argued before and not necessarily decided by the circuit court on February 7th, 2025. It's signed by Matthew G. Luzuriaga, and Mr. Luzuriaga is here.
You have anything to add, further add, Mr. Luzuriaga?
I do, thank you, Mr. Bale. Since the filing of the request, the case has actually already been postponed, believe it or not. So it's not scheduled to be heard in the circuit court until March 28th, 2025. So not that I specifically put it in the letter, but section 158-133H3D allows the board to grant one extension for up to 12 months. I'm respectfully requesting 12 months, which would put us to January 26th of 26. The reason I do that is contained in the letter is also the fact that my client is still the contract purchaser of the property. Under the terms of their contract, they're not entitled to go to settlement until they have a final approval. So at a minimum, they will not have a final approval until at least April 28th of 2025, at which point they can begin their engineering process also under the contract. They're not entitled to start until it's final. And that assumes that if the circuit court decides in our favor, a further appeal is not taken. So most respectfully, if the board is so inclined, I would request a 12-month extension.
Okay, I'd like to ask a legal opinion of Mr. Dixon here. With this being extenuating circumstances, in my opinion, and where the 12-month timeline could be very problematic in getting a site plan, Mr. Luzuriaga said April 28th, I think, and until January, that doesn't give them a full year for a site plan, and this isn't a simple lot. This is more than a residential lot. What are our options if, in fact, that timeline isn't met, or if it's not in Mr. Luzuriaga's client's favor and he appeals that decision? How do we deal with that going forward?
I don't remember this situation happening before. I mean,
That's-
we've had cases in circuit court before, but nothing, it hasn't affected the site plan process.
And because they're the contract purchaser, I'm just saying, if I was a contract purchaser, $0 would be put into anything except the appeal at this point. It's not like I would go forward with plans that could be overturned by the court system. So, I'm in favor of the 12-month extension, don't get me wrong. However, my question is, what can we do as a board if we have something down the road that like Mr. Luzuriaga described?
Well, what I'm thinking is that one way to look at it is the appeal to circuit court sort of suspends the whole process until that gets resolved. And then if you look at it that way, then this wouldn't even be necessary. It's not, they don't really start, but I don't know whether zoning is going to. I'm not sure how they're going to weigh in on that. They may look at it strictly 1 year, and
you're saying in a perfect world, the clock stopped.
that's one way to look at it. It's told until that's decided. But
Yeah, it's
I just
held-
haven't
it's
dealt
held
with
in
it before.
abeyance, For sure.
So, Mr. Luzuriaga, based on that, would you like to amend your request?
No, most respectfully, because the timeline is enforced by development review. So unless I were in a position where I had that coming from development review, that's what they were going to accept, I'd prefer if we proceeded this way, and I could explore that in the next 12 months while I have that in hand. I mean, the other option is, and I was thinking about this because I've never had a case where this has been a problem, but I know that I've had zoning cases go to the Court of Special Appeals, and that moves it beyond 2 years, so I must not have had a site plan involved with any of those decisions. This is something that really begs for an amendment to the code, to either specifically say, if there is a pending appeal, your time is told, or gives the board additional authority beyond 12 months under certain circumstances. So maybe I'm ignorant in saying that you don't have the ability to just tell development review right now that our time has stopped. I'd feel a lot better hearing that from Mr. Hine, and I don't know that that
Instead
would
of
be the
using the word
case.
extend, can we not just vote that we suspend it?
Let's not get into new territory.
Yeah, it's the new territory.
No,
Okay.
let's
Okay,
let's do it
here's
the
what-
way we've always done it at this point.
Mr. Luzuriaga, based on the scenarios that you laid out, I mean, I think what we should do as a board is go ahead and grant the 12-month extension, which would give you till January, did you say January of '26?
Correct, January 26th of 2026.
Okay.
And that's to have the concept submitted. So
Oh, that's only concept.
right, so the
Oh,
timeline
oh,
right
oh.
now we have is 6 months to have a concept plan in and accepted, and we can't even do that.
Mr. Chair, we have the ability to grant further extensions.
Well, no, that's the issue, because you only have the authority to grant a one-year extension, so that's what we're
We've-
running up against.
We've granted before, haven't we?
No, 1 year.
I don't think so. We have piggybacked on a 6-month suspension and
that's
add
right,
6
yes.
months to it. But
Right.
I don't think we've ever, gone down.
Well, wait a minute, could we do it that way? Could we grant a 6-month and then a 12-month after it?
I think it's cumulative.
Yeah,
Yeah.
let's go with that, and
All right.
Mr. Zuriaga did point out, with his specific case, and I hate changing code based on one specific case, I want to say that. I've been like that for 30 years on these boards, I hate doing that. But the code does not address the circumstances that you and your client are presently in.
I gotta think it'll happen again at some point, but maybe I'm wrong.
I'm absolutely surprised in my time on this board that we haven't seen that, but, yeah.
Well, one other last point. Is it possible to ask for a legal opinion from the county to set up a?
Well, here's what I say, give them the 12 months and we'll let them worry about it in that 12-month time period,
That sounds good. I like that.
so, okay? Any other discussion?
I have nothing.
Thanks for complicating a very simple issue.
Anytime, anytime. Happy Thanksgiving, everybody.
Don't you guys usually vote, or?
Yeah, let's get, motion, guys, motion.
What was the case number?
6515.
In case number 6515 before the Board of Zoning Appeals, the board approves a 12-month extension to the application.
Till January of
Yeah,
2026.
January 26, 2026.
Second?
Okay, any further discussion? Seeing none, all in favor, aye.
Aye.
All opposed, no. Motion carries. Thank you, Mr. Luzuriaga.
Thank you all very much.
Okay,
Happy Thanksgiving.
we have another request for extension.
Yes, we have a November 25th, 2024 letter from Randy Bechtel. Request for extension of site plan approval. On behalf of the applicant, he's requesting a 6-month extension of the site plan as outlined in the May 30th, 2024 decision letter. There's an attached concept plan submitted to Carroll County Health Department for additional percolation testing. He has intentions of completing the project. However, in the last several months, Mr. Amadei has had health-related setbacks, which have hampered communications with BPR LLC on working with this project.
What case was that?
This is case 6493.
Okay. Mr. Bechtel, you're in the audience there. I forgot to tell Mr. Luzuriaga, please identify yourself for the record, please.
Yeah, good morning, everyone. Randy Bechtel with BPR LLC.
You have anything to add, Mr. Bechtel?
Other than it's been an extreme difficult time communicating with this fella, he has, over the past 6 months, had some major big-time health issues. And the last conversation I had with him, he has turned the authority over to myself and BPR to where we're going to continue to process the plan for him.
Any questions for Mr. Bechtel?
Yes. Mr. Bechtel, is 6 months sufficient?
We don't know that. We would love to have 12 if you have the ability to give us 12.
Are there any previous extensions?
Not on this particular case.
Oh, yes. Yeah, there were extensions for the
Mr.
other case.
Mr. Amadei had previously come before
Right.
us and asked for extensions, but this 6493 actually started from scratch. So this was
one's
not,
clean.
yes.
Yeah, that's
I would suggest
consequently,
12?
So is 12 agreeable, Mr. Bechtel?
yes.
Okay, that doesn't mean that you can slow walk this. That means you have the ability, in case there's unforeseen. I'm
I
just,
don't want to come back again.
and
I don't want Domenico's issues either, but I do not want to come back to the board.
this was a surprise, the additional perk testing on the lot?
Yes.
Okay.
So what would be the new date?
Just grant
I don't know the date. You just grant the
Just
year
grant
and we'll look at the
12-month
letter
extension.
and
Okay.
look at the decision and determine that.
Yeah,
Your letter was dated May 30th, and that's why I was back here today, so, if that means anything.
We'll just go to 12-month and we'll let them sort out the date in the letter.
May 30th, 2025?
Well, no, just 12 months.
It's 12 months,
12
okay.
month.
So you want me to do a,
And no further discussion?
So that's November of next year, November 20,
We'll see what the date is on the file, but, come forward. Make sure you identify yourself, please, for the record.
Good morning, Anastasia Yemelyanova, and do I need to spell my name?
No,
Yemelyanova. I'm a zoning administrator, and the address is 225 North Center Street, Westminster, Maryland, 21157.
Okay.
And the date for the hearing that was here, the due date was January 26th of 2025. So the next, so for 1 year, it will be for January 26th, same like a previous case.
the same as the previous
Yes.
case? Okay, very good. Thank you, Anastasia.
You're welcome.
so that'd be to January 26th.
Yeah, well, I just do the 12 months and just.
Just 12 months.
Yeah,
All right,
let's make sure.
okay. So in case number 6493, in case number 6943 before the Board of Zoning Appeals, that the board approve an extension of 12 months.
Second.
Any further discussion? Seeing none, all in favor, aye.
Aye.
All opposed? Motion carries. Thank you very much.
Thank you.
Okay, now on to the real business of the Board of Zoning Appeals. We have before us case number 6531. Before I get started, make sure that you've signed in on the side sheet. Go ahead and come to the tables here in front of us. I want to remind you, make sure that you leave by the same doors that you came in, so they're not trying to locate you at the end of the day. And make sure that you turn any electronic devices to silence. Okay, Mr. Dixon, would you go ahead and introduce the file for us, please?
All right, case 6531, a request for a variance of 190 feet for an accessory dwelling unit connected to a workshop. The site is located at 2154 Enoff Drive, Westminster, Maryland, on property zone C, Conservation District and Election District 9, by Marcia Nussbaum, Code of Public Local Laws and Ordinances, Section 158.071.02A8H. A site visit is tentatively scheduled for November 20th, 2024 at approximately 9:15 a.m. And file this matter, we have the following documents. Site minutes. A response to Joe Vance's request to various state and local agencies from Andrea Hanley, Carroll County Environmental Health Department. Proposed use may not be acceptable unless it is demonstrated that there is an adequate water supply, an adequate area for the installation of an initial and 2 replacement septic systems for the proposed use and any existing uses of this property. There is a response to Joe Vance's request from Laura Matthias, Bureau Chief, Development Review. There are no comments from the Bureau of Development Review. There is a response to Joe Vance's request to various state and local agencies from Mary Lane, Bureau Chief, Bureau of Comprehensive Planning. All right, there is a November 19th, 2024 memo from Andrew R. Gray, Comprehensive Planner. Planning standpoint will be addressed during the building permit process. There is a response to Joe Vance's request from Janet O'Meara, Bureau Chief, Resource Management. Plan must address stormwater management. There is a comment memo from J.P. Smith Jr., Program Manager, Ag Land Preservation Program. This property is not in ag preservation. I have no comments at this time. There is a comment memo from Anastasia Yemelyanova, Zoning Administrator. No comments. Please see attached sections of the code, chapters. Hearing notice was posted October 18th, 2024 by Zoning Inspector Michael Roth. There is a notice of public hearing, October 28th, 2024. Let's see, I see a drawing in here. There's a few drawings. I would ask that the file be entered into evidence.
Do I have a motion to enter the file into evidence?
So moved.
Second.
All those in favor, aye.
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 All opposed, no. We'll move the file into evidence. Let me explain the process we go through. You will go ahead and present your case. We'll do that. You go ahead and present your case. After each person speaks, the board will have the opportunity to ask you questions of your testimony. You'll have the opportunity for summation comments, and then we will go ahead and deliberate the case. But before we do that, could you please stand and raise your right hand? Do you swear or affirm under the penalties of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay, you can be seated. Okay, and make sure that you state your name, address, and occupation, and spell for the record your last name.
Good morning. My name is Marcia Nussbaum. That's N-U-S-B-A-U-M. My address is 2154 Enoff Drive, Westminster, Maryland, and my occupation is Senior Director of Academic Services at Carroll Community College. Good morning. I'm coming before you today to ask for a variance of 190 feet for an accessory dwelling unit that will be attached to a workshop. I understand that due to the variance request being more than 100 feet, the board must be provided with solid evidence. My father bought the property that now has been subdivided into Enoff Estates in 1998. I purchased the lot from my parents and built a house at 2154 Enoff Drive in 1999. Since 2003, as a single mom, I raised my 4 children on this property. My parents moved to the lot next door in 2004, which was a tremendous help to me as my children were 4, 7, 9, and 12 at the time. This property has been a fantastic place to raise my children, where they have been very fortunate to grow up next door to their grandparents. Living this close has fostered very significant and strong relationships between my children and their grandparents. With the upcoming marriage of my youngest child, I've been thinking about what my next steps are. I've really enjoyed living in this quiet neighborhood surrounded by supportive neighbors. My parents will be turning 82 in the next 2 months, and I would not want to downsize and move away from my current property, since being next door allows me to be readily available to help whenever needed. However, my current home is way too big for me. My son, his fiancée, and I would like to build a barn-dominium on the property. This building would serve as a workshop for my son and include a condo for me. This arrangement would allow for the young couple to start their new family in the primary dwelling. The condo would be considered an ADU defined in Code 158-07102. Today I'm requesting a variance as defined in Code 158-002, and I've brought my son with me today to showcase the unique circumstances of our lot that have caused us to ask for this variance.
Okay. Questions? And you're going to share with us the unique features of the lot. One question I have before we even get started, I don't see it on the sheet that we have. What is the acreage of your lot?
It is 3.19 acres.
Okay, any questions of Mrs. Nussbaum's testimony?
I was just curious what size the barn dominium is going to be, square foot.
994 square foot, yeah, under the 1,000
Oh, yeah.
maximum.
The condo part, yes. Sorry.
You would go ahead and
Sorry.
state for the record
Yeah.
your name.
Good morning. I'm Jonathan Nussbaum, Nussbaum. Address is 2154 Enoff Drive, Westminster, Maryland, 21157. And I'm a design and prototype engineer for a biotech firm in the county here.
Secretary, did you have a question?
No, no,
Okay.
thanks.
Okay, Mr. Nussbaum, you want to go ahead and give your testimony?
Yeah, sure. Good morning. I'm here today asking for approval of a variance to build an accessory dwelling unit further than the 50-foot maximum from the primary residence mentioned in Carroll County Code 158-07102. I would like to break down the reasoning for the variance in 2 parts. The unique circumstances, this being the challenging lot, conservation zoning, well location, septic location, and a private road. And secondly, addressing the hardships, poor perk tests, and grading and topography. I have an updated packet that I would like to enter into evidence as an exhibit.
Okay, go ahead and give those to Mr. Dixon, and he'll label those, and we will enter those into evidence.
Can you give me one of those, Mom? Thank you. There's 8 of them there.
This is called Exhibit 1.
Okay, and we will go ahead and accept that into evidence.
I would like to note that the location of the living area has been flipped to the opposite side of the workshop there as the previous drawing you guys have. This is due to the proposed driveway location and the direction of the sun being more focused on the ADU living space instead of the workshop there. To address the unique circumstances, this lot is a conservation zoning district. Conservation zoning means that there must be 50-foot setback on all property lines, as indicated on the first page of Exhibit 1 there by the dashed lines, have that 50-foot offset of the property line. The dash red curved rectangle around the primary residence shows the 50-foot distance from the residence, which is the region where the code would like the ADU to be located. To the right of that is the well location in the center of the red circle. The red circle is the 50-foot setback the health department dictates the well must be from any foundation. Moving to the left side of the primary residence is the septic system and drainage field. The bold red rectangle around it is the setback from the drainage field where the health department dictates nothing can be within that area. This eliminates any possibility of the ADU being placed on that side of the residence without a variance, because the ADU could not both be clear of the property line setback, the septic setback, and within 50 foot of the primary residence. Finally, this property is located on a private road. The location of this private road allows the proposed ADU location to have easy access to this private road without interfering with the current infrastructure or mature trees on the property. Now that I've explained the unique circumstances, I would like to address the additional hardships. Moving to the second page of Exhibit 1 there, shows the documents given from the health department when a records request was placed. This shows the original perk testing done in 1998 when the primary residence was being planned to be built. The poor drainage on the east side, which is the right of the property, shows the failed perk tests 7, 8, and 16 on the maps, indicated with those red circles. This forced the neighbors on that side of the property to install a sand mound to pass the health department's requirement for a septic field. I have been working with Matt Shipley from CLSI, and he is confident that the proposed location offers the best potential for the secondary septic system required by the health department for a septic structure to pass their requirements. Finally, the third page of that packet. This page shows the primary and secondary contour lines of the lot. There is an 18-foot elevation change over the 190-foot span from the primary residence through the septic field to the proposed location. Moving the ADU any closer to the primary residence would have a minimum of a 6-foot slope across the 40-foot width of the proposed building. This would either require significant regrading of the property, including large amounts of fill dirt, a retaining wall, and an intensive drainage system, or would significantly interfere with the desired use case of the ADU. Using a staggered design for the structure to allow it to be built on a slope like this would require 3 to 5 steps to get from the garage into the first floor of the ADU, making it significantly harder for aging family members to safely utilize this space. The proposed location is highlighted in blue, and the entirety of the building will be on the same grade plane, resulting in the avoidance of significant alterations to the landscape. This location preserves the natural features of the property and maintains its ecological integrity. The final page of the packet shows a rendering of the proposed ADU. It will be a dark shade of blue with a gray roof. We worked with Anastasia on this proposal, and she thinks it is a feasible variance from her standpoint. This ADU would have no adverse effects on any of the adjoining neighbors, and I have signed letters attesting that I would like to enter as an exhibit.
Okay, while she's presenting them to Mr. Dixon, we'll enter those as applicants number 2.
Yes.
We'll accept those into evidence.
Thank you.
For my, could you show us where the existing backstop is for the former ball field?
If you you want me to approach? Is that easiest for you? I can-
Yes, which map are we looking at, 1, 2, 3, or 4? Or 1, 2, or 3?
Probably 2 will be the easiest due to that being, so this is the existing backstop there. Is right on that sorry, 3. So it's right in that location.
Right there?
Yes.
Actually, it's a little darkened area.
Yeah.
Okay. I just wanted to get that, because I see it's not where the existing little storage shed is, which is shown there. Okay. Everybody get that? I don't know if you guys looked at the backstop or not, but it's about halfway between that existing shed and where the,
Mm-hmm, that's fine.
any questions, board members? No questions?
Straightforward. The only question I would have is, does the health department not require a space for the repair field if the existing septic system fails?
Yes, so
It
they,
looks like where the new proposed septic field would be the logical place where the repair field would be.
so, working with, Mr. Shipley there, he's kind of confident on doing almost a split septic system if this one, doesn't fail. He wants to redo the perk testing, but he estimated it would be about $10,000, and suggested that I wait till I get approval from the Board of Zoning Appeals before spending that, on a septic system.
So this would be a mound system that you'd be putting in that place?
He's not positive yet, but he thinks that they can do that if the standard approach fails.
Okay, understood, thank you.
And on the front map, you have a conservation easement there in a triangle.
Yes.
What, whose is that? What
That is our property, but it's just zoned as a conservation easement. I'm not really, that's kind of all the information I have on it. It's a section of trees at the back end of the property that you saw behind the backstop.
Is it a forest conservation easement?
Yes.
Okay. Instead of a conservation easement, it was forest conservation. Okay. That had me intrigued.
Sorry about that.
Okay, any other questions, guys? Okay. Presentation of testimony and evidence is now closed and summations are in order.
In summary, the uniqueness of the lot and the addressed hardships meet the threshold of the variance standard. The combination of the private road, conservation zoning, the 50-foot setback requirement, septic field, and well locations, the previous perk test results, and excessive grading needed due to the topography of the property all support the need for a variance. Thank you for your time and consideration.
Okay, the hearing and record of this case is now closed, and in accordance with the Open Meetings Act of Maryland, the board will now consider the case. Board members, who wants to go first? Go ahead, Mr. Caldwell.
Good morning, sir. I think you presented your arguments very well, very thorough. I applaud you on that. It's nice to see somebody who's really gone through this and thought it out. You're between a rock and a hard place as far as this lot is concerned. I don't see any way around this, whatever you do, apart from move. That's the only thing you can do. As far as I'm concerned, I think you've exhausted all possibilities. I'd be in favor of approving this variance.
I love a family compounds, and I'm really hoping that my kids are watching this, and I see no reason not to approve it.
Hope those words don't haunt you.
I hope
Ms.
my
Eckert.
children are not watching this. I don't have anything other to add than I think it's been clearly demonstrated that you meet the requirements for us granting this variance.
Mr. Snyder.
I don't have any problems with it.
The only other place I could see that it could be located would actually be in back of the primary residence. But because of the proximity of the well to the property line and the primary residence to the right as you're looking at it from the street, and the septic system there to the left, that would literally be going round Robin Hood's barn with a driveway in order to access that. So I think the drawing with the dimensions absolutely points out the building restriction line and the practical difficulty and unreasonable hardship that it would cause with our zoning regulations. And I'd like to add, this very unique. Look, I was in on the committee that, with the accessory dwelling units, and they said 50 feet. This is nearly 4 times as much. And that's what gave me heartburn when I first looked at it. But when looking at the actual plan, I understand the hardship that would occur if that was adhered to on the backside of that residence. That's the only place that I can see it would go. So with that, and the other thing is, the lot is very unique in its shape. And that's one of the things that we need to take into consideration. This is a unique, this is not a precedent setting that we're gonna go to 190 feet on everybody that comes through.
I agreed with that.
Yeah, I agree with your thought process, because we've taken a rather relatively strict look at accessory dwellings in the past. But again, in this particular situation, the way the lot lays, the location of the lot, all the variables kind of align. I don't see, I understand the 50 feet, why wasn't it 60? Why wasn't it 40? Why wasn't it, I think that the code provides a guideline for the board to abide by. By the same token, it can't take all circumstances, lot locations and limiting factors into account when that type of decision is made. So, for that reason.
Okay. Any further discussion? Okay, board members, I'm open to a motion.
Okay, if you wish. In case number 6531 before the Board of Zoning Appeals, that the board approve the request for a variance of 190 feet for an accessory dwelling unit connected to a workshop.
Do I have a second? Any further discussion on the motion? Seeing none, all in favor, aye.
Aye.
All opposed, no. Motion carries. Our oral decision will become a final upon a written decision which will be issued within 30 days unless otherwise extended by this board. And the board's decision may be appealed by filing a petition for judicial review with the clerk of the circuit court for Carroll County in accordance with the provisions of Chapter 200, Title 7 of the Maryland Rules of Procedure. The appeal must be filed within 30 days of the date of the board's written decision. Thank you very much.
Thank you.
We call the BZA hearings back to order, and before us, we have case number 6533. Mr. Dixon, would you go ahead and introduce the file for us, please?
All right, case 6533, an application for a conditional use for a standalone daycare center. The site is located at 2710 Hampstead, Mexico Road, Hampstead, Maryland, on property zone A, agricultural district, in election district 8, by Richardson Engineering, Code of Public Local Laws and Ordinances, section 158.071.01. A site visit is tentatively scheduled for November 20th, 2024, at approximately 9:45 a.m. In the file of this matter, we have the following documents. Site minutes. There's a response to Joe Vance's request to various state and local agencies from Lisa Staley, Carroll County Environmental Health Department. Proposed use may not be acceptable unless it is demonstrated that there is an adequate water supply and adequate area for the installation of an initial and 2 replacement septic systems for the proposed use and any existing uses of this property. There is a response. There's an October 18, 2024 letter from the Planning Commission, signed by Daphne Daly, Secretary. After having reviewed the information contained in the attached analysis, the facts as presented in the application, the relevant portions of the applicable comprehensive and other functional plans, and in accordance with the land use article, this conditional use request, if granted, is consistent with the policies, timing of the implementation of the plan, timing of development, timing of rezoning, development patterns, land uses, and densities or intensities. There's an October 18th, 2024 memo from Orlisi Filat, Comprehensive Planning Technician. The above referenced BZA case has been reviewed for consistency with the policies and recommendations contained in the Carroll County Master Plan as amended in 2019, the Carroll County Water and Sewer Master Plan, and other functional plans. Planning staff finds this request for conditional use is consistent with the Carroll County Master Plan as amended in 2019. There is a response to Joe Vance's request to various state and local agencies from Laura Matthias, Bureau Chief Development Review. In accordance with Chapter 155, a site development plan shall be processed. Contact the Bureau of Development Review. There is a response to Joe Vance's request from Thomas Harris, Permits and Inspections. All comments from a permits and inspection standpoint will be addressed during the site plan and building permit process. There is a response to Joe Vance's request from Janet O'Meara, Bureau Chief, Resource Management. See attached. There is a response to Joe Vance's request from Anish Thomas, State Highway Administration. Comments, no objection to this request. There is a response to Joe Vance's request to various state and local agencies from Anastasia Yemelyanova, Zoning Administrator. No comments, see attached sections. There is a response to Joe Vance's request from J.P. Smith Jr., Program Manager, Ag Land Preservation Program. This property is not in ag preservation. I have no comment at this time. Joe Vance sent a October 28th, 2024 memo to various state and local agencies. Notice of public hearing was on October 28th, 2024. Hearing notice was posted October 18, 2024, by zoning inspector Michael Roth. And then I see some drawings from Richardson Engineering. I would ask that the file be entered into evidence.
Do I have a motion to enter the file into evidence?
So moved.
Second?
Second.
All those in favor, aye.
Aye.
All opposed, no. We will move the file into evidence. Did you guys sign in on the sign-in sheet on the side?
I did not, sorry.
Okay, before you leave, make sure you do, and it is specific to this case. If you're going to testify here today, could you go ahead and stand and raise your right hand and take the oath? Do you swear or affirm under the penalties of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can have a seat. The way you were here for the earlier case, what we'll have is the opportunity for you to present your case. The board will have the opportunity to ask you questions of your testimony, and then we will go ahead and allow you to have summation comments, and then the board will make a decision. But before you go to the microphone, please state your name, address, and occupation, and spell for the record your last name.
Absolutely. Good morning, everybody. My name is Brian Kowalczyk, representing Richardson Engineering. My last name is Kowalczyzyk.
Could you
And-
pronounce that again?
Sure, Kowalczyk.
Okay.
Our company address is 7 Dennison Street. And that's Denison.
Okay.
A little off spelling, and that's in Timonium, Maryland, 21093. I am the project engineer for this particular project that we submitted. And if you would allow me, I can go into describing the project now.
Yes.
So this project is located at 2710 Hampstead, Mexico Road. It is part of the Coppermine Sports Complex, and the overall site area is 18.9 acres. The limit of disturbance for the proposal is 1.5 acres. Zoning is an ag zoning. It's in a Patapsco River watershed. Utilities are private, both water and sewer. The existing use is the, as I said, multi-sport recreational complex. The proposed use is the same complex plus a standalone daycare facility. The proposed building area is approximately 11,900 square feet. There is 1,010 square feet of existing building that will be removed as part of this. The approximate height structure is going to be 32 feet 7 inches. And of note, the last zoning case that went through in 1996 was for conditional use of a mini golf course, batting cage, and driving range facility, which this proposed development will occupy that same space. There is no floodplain on this property. There is wetlands present in the rear of the property. Forest conservation has been addressed under the Four Seasons Sports Complex Second Amended Site Plan, S-95-028. If there's any site lighting that is required for this building, it will be non-glaring, directed away from any adjacent properties and roads. And as far as parking tabulations, we have there's a combined required use of 198 spaces. With the proposed facility and the existing parking, The provided spaces is 276. And particular note about the daycare facilities, the operating hours will be between 6:30 a.m. and 6 p.m. Drop-off time will be staggered in the a.m. from 6:30 to 9:30 and staggered in the p.m. from 4 p.m. to 6 p.m. The facility itself, so there is an existing daycare facility in the sports complex. That is primarily for use of individuals going into the sports complex and using the facility. What's going to be outside and what constituted this conditional use is a standalone. So it's going to be for both anybody that is using the facility plus any individual that does not belong to this facility that would like daycare for their children. So it's kind of a combined use. And for that reason, we are here presenting that today. Do you have any questions?
Board members?
So I have a quick one. So the daycare that's currently in Four Seasons, will that remain, and this will be in addition to?
So my name's
Yeah, go ahead.
my name's Alex Jacobs, Jacobs, and I am the owner of Coppermine Four Seasons LLC and Four Seasons Partners LLC, which owns the real estate there. Answer the question now.
Yeah,
So
yes.
yes, ma'am. So this will replace what's inside. So we will move the daycare to outside, and it'll be operated by Berry Patch, who already has an existing daycare in the community.
Okay, thank you.
And maybe I missed it, the number of, the capacity that you will be experiencing at the proposed daycare when completed?
Yeah, the capacity, I did not mention that. So there will be 113 students and approximately 20 staff members.
Mr. Colwell?
What size is the current daycare in the existing facility? How many students?
It's about 40 right now. We have about 2,000 square feet. It's a before and after school program that's typically where the buses drop off for those students in that area.
So this new one will be roughly, what, 3 times the size in terms of capacity?
That is correct, yes, sir.
Okay, thank you.
Any other questions? Mr. Jacobs, you want to add anything?
So there is a need for what we're proposing. We're not the ones that are going to operate this. There's a need from Berry Patch that has requested this for several years for us to construct. We love this area. It's a great neighborhood, and serving the community is something we've been very astute at doing. And there's definitely a need for the younger children to have some sort of daycare option, because several, I believe, have closed in the last few years, and this is a need in the community. So.
Any questions on Mr. Jacobs' testimony? Mr. Kowalczyk, anything to add?
No, other than, I mean, I would, agree with Mr. Jacobs and I don't know the exact details of the number of daycares, in the facility, but the land use that's available to have this, in conjunction with the sports complex and the opportunity that how much traffic it brings in through the community, I think it's a very, viable solution and need.
This has nothing to do with the approval, but how long ago has it been since the putt-putt golf course was actually used? Because it kind of looked like a little jungle, and I had forgotten that it was even there.
So we took over that facility in 2019, I believe, or 2018, and it wasn't, there were remnants of people using it. We didn't use it at all for our camps or anything, so we acquired that, and it was pretty overgrown at that time. The batting cage was obsolete, and there just was in shambles, so it wasn't used at all when we took over.
Just curiosity. Okay, would either one of you like to make any summation? Wait a minute. Presentation of testimony is now, and evidence is now closed, and summations are in order. Would either one of you like to make summation comments?
I would say that, again, it's Alex Jacobs. The times that the daycare is in use is typically are slower times. If you come by our facility, the height of the times that our parking lot's being used and the traffic is around 5:30 on, and those are the typical sports programming, leagues and rentals on our facilities. So this actually works very well with the traffic flow. We're not that busy in the morning at all. Our parking lot's not that busy. And then after the children are picked up, we start to get busy from that 6 o'clock to 9 o'clock at night timeframe.
Okay. The hearing and record of this case is now closed, and in accordance with the Open Meetings Act of Maryland, the board will now consider the case. Board members.
I'll do it first. There's clearly a need for daycare facilities. There always seems to be a shortage as the population grows in Carroll County. The need's going to keep going on. So I think it's a very smart use of the space, and I'm very much in favor of this project.
I agree. I think it's a very good use of the space, and I don't see any reason why it shouldn't go forward.
Second.
I think it's gonna be a complementary use to the existing facility that's there. Obviously, it's already been operating on a different scale within your facility. It's gonna meet the needs of the community. There's no opposition here, which is very telling for me, and I think it clearly meets the standards of the Schultz versus Pritz standards. I'm ready to vote in favor.
I agree. The only thing that comes to mind is traffic, which is what anybody's gonna talk about, but I'm sure that'll be addressed in the site planning process. So conceptually, I don't have any problem with it at all.
And my only comments are that I don't see where this use in this location would generate any adverse effects greater than elsewhere in the agricultural district. So I just want to make sure that's in the record. Okay, board members, I'll entertain a motion.
I'll do one for you.
Okay.
In case number 6533, before the Board of Zoning Appeals, that the board approve the conditional use for a standalone daycare center.
Second.
Okay, any further discussion on the motion on the floor? Seeing none, all in favor, aye.
Aye.
All opposed, no. Motion carries. Our oral decision will become final upon a written decision which will be issued within 30 days unless otherwise extended by the board. The board's decision may be appealed by filing a petition for judicial review with the clerk of the circuit court for Carroll County in accordance with the provisions of Chapter 200, Title 7 of the Maryland Rules of Procedure. The appeal must be filed within 30 days of the date of the board's written decision. Thank you very much, and this hearing is adjourned. Call the Board of Zoning Appeals hearing to order, and before us, we have case number 6527. Mr. Dixon, would you go ahead and introduce the file for us, please?
All right, case 6528, an appeal of a decision made by Development Review regarding a decision in the pre-submittal stage. The site is located at 2901 Mount Ventnus Road, Manchester, Maryland, 21102 by John and Catherine Gunzik. Code of Public Local Laws and Ordinances, Section 158.133B1A. A site visit is tentatively scheduled for November 20th, 2024 at approximately 10:15 a.m. In the file of this matter, we have the following documents. Site minutes. Hearing notice was posted November 20th, 2024 by zoning inspector Michael Roth. Notice of public hearing, October 28th, 2024. There is a response to Joe Vance's request of various state and local agencies from J.P. Smith Jr., Program Manager, Ag Land Preservation Program. This property is not in ag preservation. I have no comment at this time. There is a response to Joe Vance's request to various state and local agencies from Anastasia Yemelyanova, Zoning Administrator. No comments. There's a notice of public hearing, September 30th, 2024. There's a September 10th, 2024 letter from Timothy C. Burt, County Attorney, to Bradford J. Webb, Esquire. There is a There is a May 7th, 2024 email from Laura Matthias to John Gunzik. There is a typed statement, memorandum. Multiple pages from Bradford I. Webb, Esquire. I would ask the file be entered into evidence.
So moved.
Do I have a second?
Second.
All those in favor, aye.
Aye.
We will go ahead and move the file into evidence. Again, make sure that you sign in on the clipboard that was on the side, maybe it's in the audience, That's good. Make sure you do that before you leave. Make sure when you leave here today, you leave by the same door that you came in. Just don't go out those doors, and turn your ID badges in so they're not trying to locate you at the end of the day. And if you have any electronic devices, please turn those to silence. I have a disclosure. I knew Mr. Gunzik 35, maybe 40 years ago when he was the manager of an agricultural dealership in Kemar. I did no business with that business, with that particular business or with John, but I just wanted to disclose that I do know him from many, many years ago and have no business relationship with him. If you're let me explain before we do the oath. Let me explain the process. Mr. Webb will go ahead and present his case. He'll call witnesses. At the end of each witness's testimony, anyone in the audience can ask them questions of their testimony. The board will have the same opportunity. I'm assuming Mr. Webb will have more than one witness that he will be calling to. And then the development review will put on their case. I'm sure there's going to be at least one witness because she's sitting here with us. So that, and after that process, then anyone from the audience can give their testimony. Up to that point, everything needs to be in the form of a question to the witness's testimony. So I promise you, you'll get the opportunity to testify on your own. In the beginning, it's only questions of testimony that we've gotten. With that, if you plan on testifying here today, I'd like to ask you to stand and raise your right hand. So if you plan on testifying, stand. I won't charge you. So if in doubt, please stand, because otherwise I got to make you take the oath later on. Okay. Do you swear or affirm under the penalties of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Yes. Very good. You can be seated. Okay. And I'd like to remind everybody, when you go to the microphone, please state your name, address, and occupation, and spell for the record your last name. Okay. Mr. Webb.
Good morning, Mr. Bale. Good morning, members of the board. Thank you for allowing us to present our case here today. My client, John Gunzik, and his wife Kathleen own 5 parcels of land here in Carroll County. They intend to go through the subdivision process. We're at this stage, we're at the most preliminary of stages in this process, and that's just counting the maximum amount of potential lots, the lot yield, in accordance with the ordinance. There's been no concept plan, there's no preliminary site plan, there's no site plan. All of the considerations regarding compliance with subdivision regulations happen down the road. We're just not there yet. This is just the math. We're counting lots. In counting the lots, one of the parcels, parcel 11, part 3, is divided from the other parcels by a fee simple public utility strip purchased by BG&E. What's at question is whether or not the 2 lots that are available from parcel 11, part 3 can be transferred to the adjacent lots and included in the number. Period. That's all we're here for. Obviously, we believe those 2 lots are to be counted in accordance with the regulations, the ordinances, and the Bureau of Development Review has denied that. So we want to do our concept plan, but we don't know how many lots we can use. So we came here very quickly. Instead of waiting for the concept plan and get denied and then come then, we're here now. So we get this very, very preliminary matter straightened out right now to save the client money down the road.
Wait a minute. We'll give you opposition counsel the opportunity to give opening comments. Do you have any opening comments?
Of
course I do. Good morning, Mr. Chairman and board members. My name is Liz Moore, Assistant County Attorney, and I am here on behalf of the Bureau Chief of Development Review, Ms. Laura Matias. Ms. Matias and I appear before you today in regard to an appeal from the decision made by the Bureau Chief of Development Review in regard to lot yield during a pre-submittal stage of development creation. For a bit of background, the property is located at 2901 Mount Ventus Road, Manchester, Maryland, and is owned by Mr. John and Catherine Gunzik. The property is zoned agricultural. It should be noted that of importance to this matter is the fact that 2901 Mount Ventus Road is divided by a utility easement owned by BGE that divides parcel 11 in fee. When BGE parcel was recorded in 1968, the southern portion of 2901 Mount Ventus Road became an independent parcel. The southern portion of parcel 11, part 3, is the center of today's appeal. On June 5th of 2023, the Carroll County Bureau of Development Review received a pre-submittal conference form from DRS and Associates, a land design consultant firm, along with a request for development review to meet with Mr. Dan Staley. In August of 2023, Development Review notified Mr. Staley that Development Review had reviewed the proposed lot yield tabulations and that all parcels were agreed on except the portion of parcel 11, which lies south of the BGE in fee strip. Ms. Matias informed Mr. Staley that the parcel south of the BGE strip was entitled to building right, but was not entitled to off-conveyance or to any subdivision lots because it did not meet the criteria to subdivide. The criteria to subdivide includes the fact that there is no road frontage for this southerly parcel. On February 6th, 2024, Mr. Staley provided a written opinion in regard to the transfer density and parcels of land without road frontage. Further, on March 1st, 2024, Mr. Webb provided a legal opinion in regard to the proposed subdivision of the property located on Mount Ventus Road. In May of 2024, Ms. Matias informed Mr. Webb that she was of the opinion that parcel 11, part 3 was without density to transfer. She did state, however, that if it could be demonstrated that parcel 11, part 3 could potentially meet the requirements of Chapter 155 to result in subdivision yield, it would be approved. This appeal was filed on or about September 12th of 2024 for consideration before the Board of Zoning Appeals today. Therefore, the Bureau Chief of Development Review respectfully requests that their opinion be upheld and that you concur with the determination that parcel 11, part 3 does not meet the requirements under Chapter 155 to result in subdivision yield. Thank you, Mr. Chairman and Board.
Thank you. Mr. Webb, would you like to call your first witness?
I would, sir. Thank you. John Gunzik. Please state your name and address.
Okay, it's John Gunzik. My Maryland address is 2901 Mount Ventus Road, Manchester, Maryland. Zip code 21102. My last name is spelled Gundzik.
Mr. Gunzik, are you, together with your wife Catherine, the owners of several parcels of land in Carroll County known as Parcel 10, Parcel 177, Parcel 11, Part 1, Parcel 11, Part 2, and Parcel 11, Part 3?
Yes, we are.
Is your intention to subdivide those parcels?
Yes.
Did you retain Dan Staley at DRS to assist you in that subdivision?
Yes, we did.
Did you request Mr. Staley calculate the available lot yield in accordance with Carroll County ordinances?
Yes, we did.
Did Mr. Staley subsequently advise you that Parcel 11, Part 3 would yield 2 lots plus 1 remainder in accordance with the calculations required by the Carroll County ordinances?
Yes, he did.
Is your intention to transfer the 2 lots from Parcel 11, Part 3 to Parcel 11, Part 1 as part of the subdivision of Parcel 11, Part 1?
Yes.
Has Mr. Staley advised you that the Bureau of Development Review is refusing to allow you to transfer the 2 lots from Parcel 11, Part 3 to Parcel 11, Part 1?
Yes, he did.
Will that refusal reduce the value of your property?
Yes.
Were you compensated for the value of those lots? Did you own the land when the subdivision went, when the easement went through?
No.
Okay. Are you here to appeal the decision of the Bureau of Development Review to deprive you of 2 available lots on Parcel 11, Part 3?
Yes.
Okay. No further questions?
No cross.
Across. Does anyone in the audience have any questions of Mr. Gunzik's testimony? Board members?
Yes.
Mr. Caldwell?
Good morning, Mr. Staley. Could you tell me when you bought the land?
1986, we bought the first parcel, first farm, which would have been P10 and I guess it'd be P11. And then in, I believe, around 2004 or 2002, I don't really specifically recall the year, we purchased the, I guess would be considered P11 and the, I think it's P177, I think. It's the other farm.
Okay, so you said 1986 for parcels 10 and 11.
Right.
What part of 11 did you buy at that time?
Oh, I'm sorry, P177, I'm sorry, I misstated it.
177, okay.
Right, so we purchased that in 1986, and then, I'm sorry, yeah. So parcel 11, we purchased in, I believe it was 2002 or 2004.
Around
I
that
didn't
time,
really
okay. 2002.
recall that exact date.
Were you aware of the fact that parcel 11 would not have road frontage at that time when you purchased the lot?
Well, it wasn't along the road.
I'm sorry, could you say that again, please?
It wasn't really along a road. I mean, there was an old stony lane that went through the property that was used for who knows how many years. That was the only road that I was aware of, and that was the access to the property.
Okay.
Any other questions? Okay, very good. Mr. Webb, would you like to call your second witness?
Does the public get the question? Him?
I gave them the opportunity,
Okay.
and they said no.
Okay. Mr. Dan Staley, please.
Good morning. Dan Staley, DRS Associates, 52 Winter Street, Westminster, Maryland. I'm a land surveyor. Last name's S-T-A-L-E-Y.
Mr. Staley, there come a time that you were contacted by John Gunzik to assist him in the subdivision of certain parcels of land he owns in Carroll County, known as Parcel 10, Parcel 177, Parcel 11, Part 1, Part 2, and Part 3.
Yes.
Okay. I'm showing you here what's been marked as Exhibit A or 1, Tim?
That's Exhibit 1.
Exhibit 1.
Mr. Webb, would you like to enter those into evidence?
I would.
Okay, well, and it's two exhibits we have?
Two. One with the yellow, and two is 155.033.
Okay, so we will accept both of those into evidence.
Thank
Go
you.
ahead, Mr. Webb, sorry.
Okay. So, Exhibit 1 is, you have in yellow, you have, please describe to the board what this is.
Well, everything that's colored in yellow is what Mr. Gunzik owns currently, which is parcel, tax map parcel 10, 177, and 11. Of course, you can see in the map, it's, parcel 11 has been bisected by the BG&E power line that separates parts of his farm into Part 1, Part 2, and Part 3.
Which of the parcels currently enjoy direct access to a public highway?
Parcel 10 and parcel 177.
So no part of parcel 11 currently enjoys access to a public highway?
Correct.
Okay. Did you subsequently calculate the yield available from each of these parcels?
I did, yes.
In so doing, did you refer to section 153.033, which is Exhibit 2, subdivision in the agricultural district, subsection A, lot yield?
Yes.
Okay, and subsection A basically, is it correct that subsection A says that in an ag zone, you get one lot per 20 acres plus whatever's remaining?
Right, you get one per 20, one for the part thereof, and you always get a remaining portion.
Okay, so 105 acre parcel would generate 5 plus 1 plus 1.
Correct.
Okay. Just a mathematical calculation.
Yes,
Been this way for a long time.
since 78.
Yeah. Doing that mathematical calculation, does that mean you're eventually going to be able to actually have all those lots when you get into the subdivision process?
Not necessarily. I mean, there's a lot of other elements. I mean, that calculation gives you the density, and then once you do that, there's, as you process a subdivision plan, there's many other elements that you need to accomplish in order to actually record it as a subdivision lot.
So when you do this mathematical calculation, do you take into effect any subdivision regulation whatsoever?
None other than 155.33.
Do the math.
Correct.
You don't consider road frontage.
No,
You don't consider floodplains,
no,
stormwater management.
no,
Does any subdivision regulation affect the mathematical calculation?
no.
Okay. Parcel 11 does not currently have road frontage, is that correct?
Yes, that's correct.
Okay, does that prevent it from being subdivided?
If you couldn't provide road frontage for parcel 11, you couldn't subdivide it, but
Okay, if he did not own parcel 10 or parcel 177, even though there's a mathematical calculation permitting lot yield for parcel 11, it would not be subdividable,
correct.
okay? So a parcel has to have fee simple access to a road to actually be subdividable.
Yes,
And that has nothing to do with the mathematical calculation.
correct.
Parcel 11, Part 3 is divided from the Parcel 11, Part 1 and Part 2 by a fee simple strip owned by BG&E. Is that correct?
Yes, that is correct.
Okay. Are you aware of a provision in the ordinances which tells you what to do with a parcel that has been separated from another parcel by a fee simple public utility strip?
Yes,
And are you referring to section 155.033 sub B sub 2?
yes.
Could you read that to the board, please?
In addition to the lots which may be created pursuant to the A district, transfer development rights,
Now, please, number 2.
oh, I'm sorry, I'm in A, B, I'm sorry. Land on either side of a public road or on either side of a strip dividing an original tract and owned in fee by public utility would otherwise be adjoining except for the existence of the fee public ownership of the road or public utility strip. Such confronting tracts may be considered adjoining under this subdivision B. The tract shall be considered adjoining only for the purpose of transferring density, but not for the purpose of increasing density beyond what otherwise is allowed.
So is it true that the effect of this statute says that you can disregard the fee simple strip and you can transfer the lots available from parcel 3, part 3 to parcel 11, part 1?
That would be my understanding reading the code.
Okay, is there anything in that section that tells you that it also has to be, meet any other subdivision regulation?
No,
Okay, this is still part of the mathematical calculation, isn't it?
correct.
So the fact that parcel 11, part 3 is divided by the fee simple strip, it had to be, do you agree that it had to be understood by the writers of this provision that the parcel would not have road frontage? It doesn't have road frontage because of the strip, right?
Correct.
So for the, to then say it doesn't have road frontage, but you can't, but they say count the lots anyway.
Right, they say that because of the strip, because of the fee simple taking of the strip, you would still count part 3 as an adjoining tract.
Just as you counted the lots for parcel 11, part 1, which doesn't have road frontage.
Correct.
Road frontage is a completely different analysis down the road, isn't it?
Well, it's a different section of the code.
Okay, but that becomes apparent when you do your concept plan, whether or not a parcel has fee simple access to.
Right. My understanding of the two sections of the code, one is if I'm transferring, it tells me how I count the density in order to transfer. Then if I want to subdivide, there's another section that tells me what ingredients I need in order to subdivide. And I think the two are separate operations, one from the other. One I can transfer, the other one is when I subdivide. And in the transferring part, there's no restriction to the elements under the subdivision part of the code.
So all you've done so far is to transfer the two lots from parcel 11, part 3, to parcel 11, part 1, correct?
That's what we proposed, yes.
Yes, and subsection B1 allows you to do that.
Yes.
Okay, transferring lots to adjoining parcels is a long-accepted and understood concept.
Yes, I mean, I've done this. I gave Development Review, I think 9 examples of prior subdivisions that we've done that are recorded that has the same situations we're talking about here today, where we had parcels without road frontage that transferred density onto an adjoining parcel that was then subdivided.
Now, transferring the two lots from part 3 to part 1 still doesn't give those two lots road frontage, does it?
Does not.
Because part 1 doesn't have road frontage.
That is correct.
But in your next step, the concept plan, that's where you will show that parcel 11 will have fee simple access to a public road.
Correct.
Through the reconfiguration going through parcels 10 and parcels 177.
Yes,
And this is common and done all the time.
yes.
No further questions?
Mr. Staley, Chapter 155, Section 033, as you've been mentioning, and Chapter 155, Section 031, they're all part of Chapter 155, correct?
Yes.
Should we not consider Chapter 155 as a whole?
At this stage of the process?
At this stage of the process, yes.
Well, again, my reading of the code is that if I want to transfer, I refer to 155.033, and then if I want to subdivide, I go to 155.031.
Is the purpose here not to subdivide?
Excuse me?
Is the purpose here not to subdivide, sorry?
Well, the purpose is to subdivide parcels 10, 177, 11, part 1, but not to subdivide parcel 11, part 3, or parcel 11, part 2.
Thank you, no further questions.
Okay, go to the microphone. Remember the rules? Name, address, occupation, and spell the record your last name.
Barbara Preston, retired. Address 2737 Mount Ventus Road. What was the other thing? Oh, Preston. Thank you. Is there any way that we can see where these parcels are that you're talking about?
Do you have additional copies that you could distribute?
I didn't know if there was a way to put them on the screens.
Ma'am, there used to be.
Okay. Can we get copies of this? I mean, if anybody else wants one. Okay. Thank you.
While you all are reviewing that in the audience, board members, do you have any questions of Mr. Staley's testimony. So, Mr. Staley, I'm a little confused, but you're saying that in the site plan, parcel 177 and parcel 11, one of three, will have road frontage due to, I'm assuming, internal roads?
Yes, that is correct.
Okay, I was assuming, but I just wanted to clarify that. And there will not be roads going to parcel 11, the number 3?
That is correct.
So it will not go underneath of the existing power line?
That is correct.
Okay, anyone in the audience have any questions of Mr. Staley's testimony after reviewing the maps? Go ahead, Ms. Preston, go to the microphone.
I forgot I had one more. Can someone explain in layman's terms, maybe a better explanation of how you determine the total number of acres that the Gunzigs own, how that calculates into the number of lots?
I'm going to object. That's outside of the scope of the questions.
Yeah, that's not actually what his testimony was about. I'm assuming that will come out in Ms. Matthias's testimony.
Okay, all right,
So
thank you.
She's the lady in charge of that.
Okay.
Any other questions for Mr. Staley? Thank you, Mr. Staley. Mr. Webb, do you have another witness?
We do not, sir. Thank you.
You promised me two, and you
2 it is.
it is. Very good. Ms. Moore?
Yes. I would like to call my first witness, Ms. Laura Matthias. Ms. Matthias, can you please state your name for the record?
Laura Matthias,
And what is your current position with the Carroll County government?
Bureau Chief, Bureau of Development Review,
And how long have you held this position?
for 12 years now.
Would you briefly describe your responsibilities as Bureau Chief?
Sure. I oversee the operations of the Bureau of Development Review. That includes the implementation of Chapter 155, Development and Subdivision of Land.
So you would say that you're familiar with Chapter 155 of the Carroll County Code of Ordinances titled Development and Subdivision of Land?
Yes, very much so.
When analyzing properties and requests during the pre-submittal stage, do you consult and follow Chapter 155 of the Carroll County Code of Ordinances?
Yes.
Can you briefly describe the process of how you go about confirming submission and the pre-submittal stage meets all the requirements under Chapter 155?
Sure. The pre-submittal requests come into us. This is a request for a meeting that we call a pre-submittal conference. And it is to include one form that's filled out with all the information about developer, owner, location of the project, et cetera, and then a sketch is submitted along with that. So then we go about understanding what the request is, taking a look at the zoning for the property, verifying that the use is permitted there if it's a development plan, and we verify that with the Office of Zoning Administration, as that's part of their code. And then if it's a subdivision, we take a look at, again, what the zoning is and if that would be permitted on that property. And then we move forward and have a meeting in general with the engineer and the owner developer of the property.
Thank you. I'm going to show you Chapter 155, Section .031. Would you please read for the board Chapter 155, Section 031, Part A?
In order for a property to be eligible for subdivision, the property shall have a minimum of 30 feet of in-fee simple frontage to a publicly maintained road.
Thank you. And would you please read for the board Chapter 155, Section 031, Part B? You can end where it starts saying where it is determined by the Planning and Zoning Commission. I think that's sentence 2.
Okay. That's a very long. Part B says, all lots being created through the subdivision process shall be designed to provide in-fee simple frontage to a publicly maintained road. The frontage shall be capable of providing vehicular access to the property.
Would you please further look at Chapter 155, Section 033, that's on, keep flipping the pages, titled Subdivision in the Agricultural District. Is the lot yield referenced under Chapter 155, Section 033 assessed using the requirements outlined in Chapter 155, Section 031 per your interpretation?
Just using that. Yes. Section A speaks to lot yield particular to the agricultural zoning district, and that is a portion and falls under as well the requirements that were just read. So the requirements are applied and the lot yield is calculated per specifically the agricultural zoning district.
Thank you. Would you please explain for the board how you would calculate density under this section and lot yield? Just so we have a further understanding of kind of how we get to the math that Mr. Staley was providing earlier.
Step one, is it eligible for subdivision? Step one. Step two, in the agricultural district, we look at the history of the property, we look at the size of the property, what's already come out of the property, and when we're down to, okay, this is how many acres and we can apply this section of code, then this speaks to the number of lots per the acreage that you have in the agricultural zone.
Thank you. At this time, Mr. Chairman, I'd like to move the Carroll County Code 155.031. We already have a copy of 033 in, but I've got 031.
Okay. You want to move that into evidence? Okay.
Exhibit 1.
Okay, Exhibit 1, and we'll go ahead and accept that into evidence.
Thank you. Ms. Matias, so the restriction on the number of lots outlined in Chapter 155, Section 033 is not just based on the size of the property and its yield as referenced in Chapter 155.033A, correct?
Can you repeat that?
Yeah, absolutely.
Thank you. Slower.
I do talk fast.
Thank you.
The restriction on the number of lots outlined in Chapter 155, Section 033 is not just based on the size or the property and its yield as referenced in Chapter 155.033.
You're referring to, we also need to apply the requirements outlined in the subdivision requirements, I believe is where you're
Yes.
going with that. So yes, both are applicable.
And Chapter 155, Section 031 should be considered in the process of subdivision prior to Chapter 155, Section 333.
Correct.
So why is Section 155.033B not yet to be considered in the instant action?
Because they're not out of the start gate yet, if that makes sense. Without the road frontage, it can't be considered for those subdivision lots, for those two lots density. I'm not sure I answered your question. I feel like I've answered that question already. Yes.
You are good.
Okay.
Are you familiar with the Gunzix property located at 2901 Mount Ventus Road?
Yes.
Can you describe why Parcel 11, Part 3 at question today does not have access to road frontage?
It does not, as currently laid out. It was split by the BGE parcel, but obviously you can all see as well that it doesn't have any frontage onto a publicly maintained road, nor could it achieve that. Can I continue to talk about this part?
So Stony Lane is not considered a publicly maintained road?
No, it is not.
Thank you. What opinion did you render when the Gunzix applied to subdivide one of the parcels on their property by transferring all the density from their adjoining tracts to the south of the public utility easement on their property?
So Mr. Staley went through the process and submitted to us each individual parcel and the calculation for what he believed the number of lots would be from each of those parcels. Obviously, that would be the first step before you can then transfer the density. What is the density? So he submitted that, and we went through and assessed each parcel for the individual yield, and we arrived at the conclusion that his Parcel 11, Part 3, I believe is what we're calling that area south, that the two lots. It is a buildable lot in and of itself, but there are not two additional lots of subdivision that could be transferred.
So the denial was not based on lot yield from one parcel to another, but was instead primarily due to the lack of road frontage as the first step to the process of lot yield determinations?
So the determination was specific to the number of lots, not in relation to the transferring of density, which would.
So if parcel 11, part 3 could potentially meet the requirements of chapter 155 to result in subdivision yield, could an additional density of 2 lot rights be transferred?
Yes, which is also, I will say, so part 1, it was noted that that does not have frontage, right? So part of the assessment is they own all of these parcels. Could they gain that frontage through a reconfiguration of their parcels? For the parcel part 1, parcel 11 part 1, yes, you could do that because you have that option to gain that frontage through the other parcels you own by reconfiguration. Part 3 doesn't have that potential, and that's what we asked. If you can provide that and show us how that could be achieved, then perhaps those 2 lots are available, but that has not been indicated to us as a possibility.
Are you familiar with the 9 additional examples that Mr. Staley submitted to you in this discussion?
Yes, I am.
So what differs between those and this particular property?
Those had that potential that I just discussed to reconfigure lots, gain that frontage, and have that eligibility. But this particular parcel does not. Those could not be considered precedents for this particular case scenario.
No further questions.
Anyone in the, oh, no, Mr. Webb.
Thank you, sir.
Sorry.
Good morning, Ms. Mattias.
Good morning.
Nice to meet you. Do you recognize the fact that parcel 11, part 3 is not going to be submitted for subdivision?
In and of itself, yes.
And no
correct.
part of that land is going to be submitted for subdivision?
Independently, correct. It is not independently being submitted for subdivision.
Right, so when you see the concept plan, parcel 11, part 3 will not be on the concept plan, right?
Oh, it will be.
Okay, but no part of
It
parcel
should
11,
be.
part 3.
I can't say it will be. That's
Parcel
Mr.
11,
Staley's.
part 3 will not be, is not being subdivided.
It is part of all of the lands being considered in this process.
Part 11, parcel 11, part 1 does not have road frontage, does it?
Correct.
So you're not applying 0.31 to part 1. You're only applying it to part 3.
So
Neither one has road frontage.
as I just explained, we do permit that vision of how a landowner could reconfigure parcels that they own in order to gain that road frontage. We don't make them go through that actual recordation of those deeds of reconfiguration in order to move forward if we can see, yes, that could happen via the parcels you own.
155.033 sub A, that's entitled lot yield, correct?
Yes.
And the purpose of this ordinance is to tell us all what mathematical calculation has to occur to determine the lot yield
In the agricultural district.
in the
correct.
agricultural district. Is there one word in that section that says that those lots have to also comply with any subdivision requirement? Give me one word.
I'm going to object. Was that necessarily a question, or?
I'm asking her to give me a word. Show me in that section where subdivision requirements are part of the mathematical calculation.
The tract to be subdivided. Subdivided being the word.
The size of the tract to be subdivided. Is parcel 11 Part 3 being subdivided?
The lot density is calculated via the subdivision potential.
Right, it's a calculation. Switching now to subsection B, utilization of adjoining lots. What's the purpose of this section?
The purpose is to speak to how adjoining tracts may be utilized for the purposes of creating lots.
And these adjoining tracts are not being subdivided, correct?
The subdivision is occurring on specific parcels where they are transferring the density from all of their lots to the specific parcels.
Yeah, for example, here, the parcel that's being subdivided is Part 11, Part 1, correct?
We have a sketch of potentially where the lots are going.
Well, you heard Mr. Staley testify that parcel 11, Part 1 is being subdivided.
All I have at this point is a sketch, and I'm not sure of the parcel lines on it, so I can't verify for you which parcel particularly the lots will be end up transferred to.
Okay, but parcels that are not being subdivided can transfer their lot yield as calculated by Section A to an adjoining parcel that is being subdivided, correct?
Please restate that. Repeat.
Correct. A parcel.
Please repeat the
A parcel that
question.
is
Yeah.
not being subdivided can transfer its lot yield as mathematically calculated by subsection A to an adjoining parcel that is going to be subdivided, correct?
I do not believe density can be transferred if it doesn't exist first. That's why we're here.
Do you agree that the mathematical calculation of Part 3 does yield 2 lots plus 1 remainder?
I'm going to object. That was outside of the scope of my direct.
Oh, yeah, it is. She's denying the 2 lots. So I just want to establish, we all are in agreement that there are 2 lots there plus 1 remainder. You're just not transferring them.
Could you?
Did you have a question?
Could you rephrase the question?
Sure. When this matter was presented to you,
Yes.
okay, at the initial stage of calculating the lot yield and transferring lots from one parcel to another, you concur, I mean, I think you actually testified that they could have the 2 lots if they had road frontage.
Yes?
Okay, so the 2 lots are there, plus a remainder.
No. Not without the frontage, not by,
Okay, the mathematical calculation only. You agree that when you do the mathematical calculation, Part 3 generates 2 lots plus 1 remainder.
I don't believe that is applicable until you meet the requirements. If we went that route, every landlocked parcel within Carroll County
Ms. Tyson,
would have yield according to you.
I'm being very specific, very narrow here,
Yes.
okay? We'll get to your issue in a moment, all right?
Very narrow.
Applying, just doing the math as established by Part A, doesn't by Section A of the statute, doesn't Part 3 isn't there the potential for 2 lots plus 1 remainder?
I'm going to object. Asked and answered.
She hasn't answered it.
I wouldn't do the math if it wasn't eligible to begin with.
Do you object to Mr. Staley's testimony that there are 2 lots in Part 3 available to be transferred?
I'm going to object. That was outside of the, my directive scope, or my scope of direct.
That's correct.
She heard us. Did you hear Mr. Staley's testimony?
Again, I'm going to object. That's outside of the
But
scope
your,
of direct.
your questions are directed at her testimony.
I'm allowed to ask her questions about testimony in this room that she heard or didn't hear.
No, her testimony at this point. What her testimony has been to this point is what you can ask questions on.
I can ask her questions about testimony given by other competent witnesses during this proceeding. I can't ask her those questions.
Mr. Dixon? It's not how we have operated in the past.
No, I would restrict it to what she testified on.
So we will restrict it to what her testimony was.
I object for the record.
Objection noted.
So I think you're just basically going to refuse to answer the rest of my questions, but I'll try anyway. B2, 155.033B2 states, where land on either side of a strip dividing an original tract owned in fee simple by a public utility would otherwise be adjoining, such confronting tracts may be considered adjoining. Do you see that language, Ms. Matthias?
I'm going to object. That was not part of the direct.
And it wasn't.
Now, this is, with all due respect, this is getting ridiculous.
Mr. Webb?
Sir. This entire case is about her refusal to transfer the lots from Part 3 to Part 1. I am cross-examining her on what the law says about transferring lots from Part 3 to Part 1. She's testifying she is not going to permit that transfer because there's no road frontage. This section right here says disregard the fact that the fee simple utility strip exists and transfer them anyway. Her case is the existence of the strip prevents road frontage. And then she wants to ignore the statute that says you are to disregard the strip when it comes to transferring the lots. I need to be able to cross-examine her on, does she even read the statute?
Mr. Dixon, correct me if I'm wrong, but he could have done that if he would have called Ms. Matthias as a witness, correct?
He could have called her as a witness, and if it's just a matter of legal interpretation, then she's not the only witness that can do that. If it's just a matter of legal interpretation, how you interpret the statute, Ms. Matthias is not the only person that can do that.
So I don't get to ask her whether or not she even read the statute?
Well, she said she was familiar with Chapter 155 because she deals with it, so
Okay,
that's already been answered.
Did you take into consideration 155.003B2 when you decided not to transfer these 2 lots?
B2 speaks to adjoining properties and the transferring of density. The tract shall be considered adjoining for the purposes of transferring the density. So yes, they are recognized as adjoining, but there is no density to be transferred.
And you say there's no density to be transferred because you can't get a road to Part 3 because of the public utility strip. Isn't that correct?
There is no, the 2 lots are not there because it doesn't meet the requirement in order to be eligible to create those two lots.
And that requirement is road frontage?
Yes.
And it can't get the road frontage because of the existence of the public utility strip? If the public utility strip wasn't there, would you have any problem with transferring the two lots?
That parcel wouldn't exist without the BGE strip. It would still be part of the other 1 of 3 and 2 of 3.
And don't you see that Section 2, B2, is intended to preserve the property rights of the property owner and the value of whatever lot yield they may have, even though they can no longer get a road there? This section specifically states you get to transfer them to an adjoining lot, and that it is still in fact adjoining, and that you are to disregard the public utility strip. Do you not see that that's what this says?
I'm going to object. That's a compound question. You can still
Could you
answer. Yeah,
restate your question?
Sure. I've been trying to break it down, but I keep getting objections. You agree, I hope, that this provision states that the purposes of transferring lots to an adjoining lot, that Part 3 is in fact an adjoining lot to Part 1.
It is.
It is. Thank you. The reason the statute had to be written to make it clear that even though the public utility strip is there, that Part 3 is adjoining, is because a public utility strip could divide the two parts, correct? That's why they wrote the statute. Because it's no longer, on a map, it's no longer adjoining, right?
It's.
I mean,
Are you
3
asking me
doesn't
why
touch
they
Part-
wrote that section of code, or are you asking me again if they're adjoining?
Part 3 doesn't touch Part 1, does it?
No.
Okay. In the strictest sense, it's not adjoining, correct?
Per the code, it is considered adjoining.
Right. And you can transfer lots from Part 3 to Part 1 per the code.
Yes.
But you're saying because the utility strip is there, which is obviously part of why they wrote the statute, he doesn't get the lots anyway because he doesn't have road frontage. Does that make sense to you? Don't you see that's why they wrote the statute?
I'm going to object to that question. That's poor form.
She doesn't have any knowledge of why they wrote the statute.
Yeah, Clay Black wrote it. All right, to be clear, you applied subdivision requirements to a determination to determination of the mathematical calculation required by 155.033, and you're applying subdivision requirements as to whether or not subsection B2 applies. Is that correct?
That was a two-part question. Can you ask that again?
Okay.
And I will answer each part as a question.
You're applying subdivision requirements to the mathematical calculation of lot yield under 155.033 sub A, right?
I'm applying the requirements prior to the mathematical calculation.
So the mathematical calculation changes whether or not a property has road frontage?
I believe I stated previously, but if it doesn't meet the initial requirements, then why go through the process of running the calculations and determining yield?
Can you show me anywhere in 155.033 that you are to apply the subdivision requirements set forth in 155.031? Show me where that says that anywhere in 155.033. Why is it not just a mathematical calculation?
So 0.033 is a part of the entirety of Chapter 155, which had previously been verified. And if we calculated simply based on acreage under 033, then every agriculturally zoned property in the county would have a lot yield associated with it. But again, the requirements come first.
Please tell me where,
Assessing a
please
lot
tell me where it
yield.
says that. Please show me where it says that. You keep saying that, and I keep asking you to point to the statute, the section in 155.033. Because for years, the first step is 033,
I'm
to
gonna-
calculate, the mathematical calculation.
I'm going to object. That was testimony.
And that is testimony.
Can you answer the question?
Can
you mind
can you
restating
rephrase that?
Show me where it says in 155.033, what you keep saying is that you were first to apply subdivision requirements prior to doing the mathematical calculation.
Those are the requirements of Chapter 155, subdivision requirements, period.
I mean, you understand that you generally apply the subdivision requirements when the subdivision is in fact presented to you, isn't that correct? The actual plan?
Again, when the pre-submittal request comes in, we assess it per everything about the property, and if we can move forward with that proposed project.
Are you assessing stormwater management requirements when they come in with the mathematical calculation?
I don't believe I mentioned that when I spoke about the pre-submittal conference.
So you don't do that?
I'm going to object. That was outside of the scope of direct.
And that wasn't in her testimony.
So is it safe to say then the only subdivision requirement that you claim to consider and as part of the mathematical calculation is road frontage or potential road frontage?
So 155.031 subdivision requirements starts with A. In order for a property to be eligible for subdivision, the property shall have a minimum of 30 feet in fee simple frontage to a publicly maintained road. That is A. We proceed from there in looking at the property's zoning, in ag, the history of the property, what has been divided out. I believe I stated this earlier, right? So we start with, does it meet requirements in order to subdivide?
Why doesn't Part 3 meet the requirements?
In order for a property to be eligible for subdivision, the property shall have a minimum of 30 feet in fee simple frontage to a publicly maintained road.
Specifically tell the board why Part 3 doesn't meet that requirement.
It does not have in fee simple frontage to a publicly maintained
Does
road.
Part 1 have in fee simple access? It doesn't it?
Would you like me to readdress that? I already spoke to that, but I can reiterate what I said previously.
What prevents Part 3 from having fee simple access to the public road?
The utility strip.
Right. And Section B2, doesn't it tell you that notwithstanding the utility strip, you count the lots anyway?
No.
Doesn't tell you that. Okay, I have no further questions then. She can't answer that question.
Okay, does anyone in the audience have any questions of Ms. Matthias's testimony? Board members, Ms. Ford Mount.
Hi. So I just want to make sure I understand. I think what you're saying is 155.031 must be met before you even consider anything in 155.033.
Correct.
There are steps that have to be met, and if they aren't met, you don't even look at the next process.
That is correct.
Of that. And so part one, you're saying visually you can see if those other lots were reconfigured, how that lot could get road frontage to be subdivided. But you're not even looking because the other one didn't meet the requirements to be viewed in that way as Lot 3. So it didn't meet the first requirement, so you're simply not even looking at the second one to go past that.
That's correct.
Okay, thank you.
Mr. Colwell.
Referring to 155.020, under compliance B, do you have that in front of you?
Zero 020?
Repeat that again.
155.020, general requirements, development of land.
Yes.
In that it says compliance in preparing a plan, the developer shall comply with all applicable federal, state, and county ordinances and regulations governing subdivision development on use of land. Is that correct?
Yes.
Thank you.
I have a follow-up question to Ms. Ford Mount's question. So you indicated that you assumed that the property owner could reconfigure to get frontage if they did not have frontage on the other parcels that were to the, I guess, the north side of the power lines. So my question to you is, recognize that it does not have road frontage now, but in accordance with the subdivision requirements in the ag zone, it says that that power line is to be disregarded as far as figuring out whether you have road frontage. So why wouldn't you have put that in there as part of your calculations because if that power line wasn't there, you would have assumed that they could have reconfigured that parcel in some other way to get road frontage, correct? Is that what you testified?
I do not believe that that section of code says that we don't look at the power line. It acknowledges the power line as having divided that property. There are other sections of code which also, for clarification purposes, is what I believe they were put in, speaks to a road that's owned in fee, a railroad that's owned in fee, a power strip, a utility line strip that's owned in fee. And the code then clarifies what that means for the splitting of that property. So that section of code is specific to, you shall consider these adjoining for the purposes of.
So in this instance, if that power line was not on this property, well, I think you first indicated that that parcel wouldn't have been created.
Correct. It wouldn't exist. It would all be one parcel still,
So
or
if it was-
two parts.
So would that density be there if it was all one parcel?
If it was all one parcel,
Yes.
then we would look at the total acreage of that parcel and calculate the yield on that.
So would they still have that density if that power line wasn't there?
So I have not run the calculation, nor did Mr. Staley run the calculation on what that total acre, it would combine, if the power line wasn't there, you would combine part 1, part 2, part 3, right? You would just have parcel 11. So you would look at that total acreage of that parcel, and then we would, acknowledging that it could gain road frontage via reconfiguration of their parcels, right? Then we would look to that section of the code that tells us how many lots in ag and those calculators in there. So Mr. Staley ran it as 3 individual components of parcel 11, which it is right now because the BGE line split parcel 11 into 3 parcels.
So in effect, recognizing that it has been split into 3 parcels, and based on what I'm reading in 155.033, it indicates that even though, I guess it's bisecting, it's been split, it's still considered an adjoining parcel.
It is adjoining.
So my question is, if it's adjoining, recognizing that the other parcels were considered as though, or the one parcel that doesn't have road frontage now, if it is still adjoining, and the only reason that it's not adjoining, it's not physically adjoining, is because of a public utility running through it, why isn't that same calculation applicable to this parcel? Because it is an adjoining parcel. It appears that they are being punished on lot yield because it doesn't have frontage because of this BG&E right-of-way.
So going backwards, predating the I believe it was 68 when the power line came through. This was one parcel, and it had, immediately, it would have had one building right associated with it. What that potential then was to subdivide, we didn't run the calculations, but when any in-fee strip, whether it's a road, a railway, a public utility comes through a parcel, then per our code, it splits that parcel. So now, part 1 has a building right, part 2 has a building right, part 3 has a building right. So that property owner, that split did occur, and that's the way the code then recognizes that happened. Now here's what you have because of that split, okay? But yet, back to the same answer, it doesn't meet the requirements. It can't, although it is a buildable parcel in and of itself, it doesn't have those 2 additional subdivision rights for the purposes of transferring.
But if it's an adjoiner, I know I'm beating a dead horse. If it's an adjoiner and you assumed on the other parcel that didn't have road frontage, that they could reconfigure in some form or fashion, in your determination of lot yield, I don't understand. I mean, we can talk about it doesn't have road frontage all day. That's a given. But neither does the other parcel that's being counted in the lot yield, because they presumably could get frontage on a public road. So it appears that they are being punished because of this BG&E bisecting their property. Even though once that happened, in accordance with the Carroll County Code, it's still considered an adjoiner. And adjoiners, the property owner is given the benefit of assuming that they can reconfigure to get road frontage. So if this lot yield goes on the other side of these power lines, then it gets road frontage. And maybe the answer is as simple when one of the other parcel, it's demonstrated that gets road frontage, that lot yield will be realized. I'm not sure. It feels to me like it's not being analyzed the same way as the parcel on the north side of the power line.
Wait a minute. And I don't know whether this is for Ms. Matthias or not. For my own edification, so that I can understand the size and scope of this, and it has not been testified to, but the information is out there, can someone give me the acreages of these parcels? Mr. Staley, could you do that? So let's start with parcel 10.
Parcel 10 is 33 acres.
33? Parcel 177.
Is 21 acres.
And that, parcel 177 is,
As it goes down into part.
So,
It's kind of weird the way you
it's an
line.
infinitely long parcel.
yeah, oh,
It doesn't have
okay.
another boundary.
Yeah, got it, okay. I see it now. There's no boundary up there along Stony Lane, it's kind of runs together. I was fooled by that, I thought it was smaller, I thought it was a lot smaller than that. Okay, parcel 11, number 1.
33 acres.
Parcel 11, number 2.
4.8 acres.
And parcel 11, 3.
26 acres.
117 acres, almost 118 acres.
Okay, that helps me. Thank you, Mr. Staley.
You have a question?
So, all of these parcels, except parcel 11, 2, are eligible for an off conveyance, at least one off conveyance.
Yes.
77,
That
well,
was 3 acres.
177 is only 21 acres, that's only entitled to one. Would that be correct?
So Mr. Staley did include the off conveyances in his calculations, and at first look, we agreed with him on everything except for those 2 subdivision lots. So yes, there are parcels entitled to off conveyances.
Okay, so parcel 11-3, is that entitled to an off conveyance without road frontage?
So road frontage is not a criteria for the off conveyances, but I do not believe that was part of the calculations.
So that does not, it's not entitled to an off conveyance.
I do not believe so. I believe this one went straight to, it's one buildable lot and two lots of subdivision, and a remaining portion is what he calculated. And again, it's been a little while. This started back in 2023, this process. So I believe that's correct.
So what I'm looking at is,
I'm sorry, Mr.
go to the microphone, Mr. Staley, sorry. And then stay there after you answer the question, because I got another question. I don't know which one of you will answer.
Parcel 11, Part 1, has already had one off conveyance. And because that off conveyance came out of Part 1, the second off conveyance also has to come out of Part 1. So you couldn't apply it to Part 3.
Thank you.
Okay.
Now I recall that. Thank you very much.
Or Part 2.
Or Part 2.
Okay, very good. So the density, assuming there was no power line, what would the difference be in the density as the present plan? If we only looked at the north side of the plan, the north side with the power line.
I understand the question.
You understand the question? If we do,
If you do the calculations and ignore the power line, you would come up with one less density unit, except for if the power line was not there and you had that acreage back in the original farm. I don't know what that acreage is, but I'm guessing you're going to be 2 units ahead. So because of the taking of that acreage, you lost density.
The accumulative effect.
Where the power line is running through, you lost acres
Because-
there, so
well,
that's
Because
affecting
the acreage
the
the power
level.
line took, you actually lost density per the calculation in 133, 155.133A.
So the 4.8 acres there on parcel 11, number 2, that's not a subdivide, that adds nothing to the density, is that correct?
Well, we would call that a hangover lot because of the taking of the power line, separating it from its parent tract. It exists as a separate parcel. It's referred to as a hangover lot. It's one lot.
So you get one lot. Does the same rule then apply to parcel 11, 3 of 3?
Parcel 3 of 3 is also a hangover lot. And again, because of its acreage, I maintain that if you do the calculation per 155.33, it's 26 acres divided by 20. You get 1 for the 20, 1 for the part thereof, and a remaining portion. Now, the interesting thing that we're talking about here, we're not subdividing part 3. We're only going to transfer the density. And my question is, we keep talking about 155.31A. In order for a property to be eligible for subdivision, you have to have a minimum of 30 foot of fee simple road frontage. My question would be, what is the property? There's no definition in 155 of what the property is. My taking of that would be the property is the project. The project in this case is parcel 110, 177, and 111. And I'm in parcel 11. Would be the property. That property as a project has the road frontage, so it's eligible for subdivision.
Okay, now this is the question for Ms. Matthias. Your testimony is that south of the power line cannot be used for the purpose of density because it doesn't have road frontage. If it could be demonstrated that it had road frontage, that would not be an issue. Is that correct?
Correct.
If it has road frontage, if parcel 11 presently had road frontage, which it does not today, could you consider the density south of the power line? Because you're taking the density.
Parcel 11, part 1?
Yes. So it doesn't have road frontage, but you're assuming, because of the entirety, that there will, in the development plan that will be submitted, that parcel 11-1 will have road frontage due to internal roads. And that's why you're able to use the density from parcel 11-1.
Can you restate the part about internal roads? Are you talking about through their development
Yes,
plan?
yes.
That's not part of the equation for the calculations up front. So
So how can the lots off of parcel 11-1,
yes.
how can that be calculated in the total development project
Sure.
without road frontage, and also parcel 11-2? Because they're both,
So, yes, correct, but
Both
both
land.
of them, again, so we could strictly say, once you reconfigure your lots and you have a deed of reconfiguration and you show us the new parcel lines, come back to us. And then we will look at this as now eligible to calculate your yield. You have road frontage now. And now to Mount Ventus? Yeah, right. So as was stated at the very beginning, parcel 10 and parcel 177, I believe was the opening from Mr. Webb, that those two do have frontage. And in fact, that was one of the first questions we asked, because that's a very interesting road that then turns and goes north into Pennsylvania. So we started with asking our Department of Public Works, is this a county road? Is this considered publicly maintained road? Do we, and the answer was yes, all of that. So we were able to verify parcel 10 and parcel 177. Now, as I said, if we wanted to take everything step by step by step and not look to that end vision of, I understand that you can do this. So we could say, you go and reconfigure your lots, come back to us when you have road frontage, and now we'll have that discussion, right? But we don't put them through those steps because we understand how that can happen because you own all that. So it doesn't, it looks at the situation as is. Did I answer your question?
So if they come in with a reconfigured deed, the lot yield on parcel 11-3 would be considered, or would not be considered, with a reconfigured deed.
Unless they could, if they could show road frontage, which they could with part 2 and part 1 is, I can visualize that, as you probably can, that they could do that to Mount, again, Ventus. Thank you. Has an N in it. But parcel 3, I'm not seeing that, which is what we conveyed back to Mr. Staley. We don't see how that parcel could be eligible. Please show us if there is a way that you are seeing that that could happen.
But essentially, I think is what you're saying is, from the beginning, you could have denied parcel 11 from the beginning because it doesn't have road access. And so actually, I can understand how you feel like they're being punished by parcel 3, but really, you're sort of giving them grace, if you will, that you can visualize that, and that makes sense, where the other one, you just would really need to be shown to be able to move forward, because essentially, you could deny parcel 11, or parcel 11 from the beginning, because it doesn't have what it needs to have.
That's true.
I've got a
So,
question.
I'm sorry. Go.
Who's first?
Well, go ahead, Lisa.
So, back to, sorry, 155.033. So, I think you testified that you agree that it is an adjoining parcel,
Correct.
the one we're talking about.
Yes.
So, in this part of the zoning ordinance, under B, number 2, it says the tract shall be considered adjoining only for the purpose of transferring density. So why can't we transfer this density? I know you're gonna say it doesn't have road frontage, but a public utility is why it doesn't have road frontage. And if that public utility wasn't there, they would have had this density. And now that it is there, I mean, the density goes away because they don't have road frontage? I mean, that,
It completely changed the parcel. I agree with you. When BGE came through and split that parcel, it changed it. It created 3 parcels, whereas before it was 1. And yes, correct. That road frontage, or as far as I can see, the ability to gain that road frontage was taken out of the equation. I agree with you.
okay, so why do they need that? Why do they need that road frontage if you can use it for transferring density? If you can just use it for that, why do they need that road? They're never gonna put a lot on that side of the road, or that side of the power line.
Again, I don't believe you can transfer the density if it's not there. And I don't believe that it's there because it doesn't meet the requirements of subdivision.
Even though it's an adjoining property. Yeah, I'm struggling with that.
It's how the code reads.
One more question. Can I ask Mr. Staley a question? Because I think he did it quick.
While they're both here, yeah, absolutely.
So you indicated that because this property lost acreage when this power line came through,
Correct,
that actually decreased the yield
correct.
for subdivision.
Correct.
So if this power line wasn't going through this property, you would have had 2 more lots based on your rough calculations on paper?
I'm guessing, I don't know the acreage of the power line taking.
Okay,
I think it's about 14 acres.
so they took 14 acres.
Okay, so that 14 acres,
And 26 is 30, is 40. So one lot.
14 out
well,
of 60.
Well, then you got to total the whole thing.
right.
Right.
14 acres out of about 60? So
think it was
so
like
it'd have been about
originally-
74?
I think it might have been close to 80, like it was 79 or so, or somewhere in that area.
So if the power line never occurred, you could have achieved 7 lots out of that tract,
Out of
the entire tract.
P11?
Out of all of it.
Out of all parcel 11, you would have achieved, and what it was 78 acres. So I would have done a 20-acre off conveyance, which would have netted, a 20-plus acre off conveyance, which would have netted 2 lots plus the remaining portion. The balance would leave you with 78 or 58 acres, and that would give you 2 lots for the 20, 1 for the part thereof, and then another remaining portion. So that'd be 3 plus, or that'd be 4. Sorry, yeah, 4 plus 3, which would be 7. What we're proposing right now is 7. If we are allowed to transfer the density from Part 3 to Part 1.
7 total lots?
Yes.
On the property, the entire project.
So
No, just parcel
the density,
11,
Parcel
part 1.
if the power line never existed, the density would be the same,
As you're going to get down.
yes.
If you
What
were
we're-
able
What
to
we're trying
trans-
to achieve now.
Is the 14 acres didn't, okay. And again, I just want to point out, no, I can't do that yet. That'd be testimony.
Question.
Go ahead.
For Ms. Matthias, you'd mentioned about the calculations, how the calculations are done. Can you
Yes.
tell me when that started? How those calculations are, in terms of, when was that made part of the process?
So Chapter 155 was adopted in 1963.
155 was created in 63.
Correct.
Okay, did it have at that time this requirement for minimum 30-foot road frontage?
That's a great question that I cannot answer.
I can, no.
Did not have it?
Did not. Did not.
It was the Wild Wild West prior to 78.
Okay, so when did it come into effect?
Um,
Do you have any idea, Mr. Staley?
Give me a minute here. Well, last time they passed 155.031 was in October of 2022. Now, I'm not sure if that's when that language came in, but if you, the code that I have with me right now, Section A, which is in order to be, for a property to be eligible, you need the 30 feet. It's like grayed out, which is the part that they added. So I can't tell you with certainty, but I think that part was added back in October of 2022.
No, sir. The 30 feet, is that what we're referring to?
Yes.
Yeah, that's been here at least as long as I have, which is 12 years, so. We did not change it with the code clarifications that we processed through in 2022.
Yeah, right.
You don't have the whole history here.
But I'm saying, this is because it's grayed out.
Okay, any more questions for either Mr. Staley or Ms. Matthias? Okay, Ms. Moore, any other
No.
follow-ups?
No.
Okay. You want to call another witness?
No.
We're striking out. Okay. Mr. Webb, you want to recall any witnesses?
I do not.
Okay.
Closing?
Now, anyone from the public want to give their testimony? Go ahead. It's been so long ago, I'm going to go over the rules again. Please state your name, address, and occupation, and spell for the record your last name.
Greg Wentz,
Okay, you're going to have to get closer to the microphone.
Greg Wentz, 733 Glenville Road, WENTZ.
What's your first name?
Greg, Greg.
Okay, go ahead, Mr. Wentz.
My question is, you keep talking that if the power line wasn't there. You're asking her questions. The power line is there. They got paid for that piece of property, so they forfeited, I feel, what you're asking them to give. I mean, the power line's there, you can't deny it. So you guys keep asking questions if it wasn't there, but it is. So I don't understand why we keep asking questions if it wasn't there.
I'm going to tell you this. The question wasn't directed to me, but I was asking from in my own mind to see if there was a difference in the lot yield, whether it was before or after. That was just one of my questions I had in my mind. So
Yeah, but
it's there. I'm very familiar with power lines right now.
Okay, thank you.
They want to put one through my property, so I'm very familiar. Okay, any other testimony from anyone? Okay, very good. Thank you for not being unruly back there in the audience. We had a large audience. Thank you very much. Okay, the presentation of testimony and evidence is now closed and summations are in order. The applicant is first. Mr. Webb.
Thank you, Board, and apologize for some of my frustration earlier, but I was frustrated. I'm going to start with answering that gentleman's question. And I can't look at you because they don't let me. When they go through and they purchase these easements, eminent domain may occur, and you have to pay the landowner the fair market value of the land being taken. If these lots are not transferable to an adjacent parcel because of the power easement, then the landowner would justifiably be able to include the value of his lost lots in the eminent domain proceeding. And there would be an appraisal of the value of those lots, and they would be paid a great deal more money. To avoid having to do that, B2 exists to reassure the landowner that with the creation of this easement, you are not going to be punished, as Ms. Eckert was putting it, but you're not going to have the loss of your value of your land taken away because, and being uncompensated for it because of the creation of the power line. The thought process of the Bureau confounds me. .033 is the first step. It is the calculation the mathematical calculation of the maximum potential lot yield. It has, other than it being the maximum potential lot yield, it has nothing to do with the ultimate number of lots that will be created through the subdivision process. There are many other factors that come into the process, and they come into the process at a later step down the road. There has never been a consideration of subdivision requirements at the mathematical calculation stage of the process. The Bureau has cherry-picked road frontage. Why not floodplains? Why not stormwater management? Why not forest conservation? Why not what happens to the area of the land that's eaten up by the roadways? All of these things come into consideration with lots you have, and perking. These are all considerations that come down the road. All we're at now is step 1, 155.033. Sub A, you do the math under various parcels. And then B1 says, with respect to a tract that's not being ultimately subdivided, but you have an adjoining tract that is going to be subdivided, we're going to allow you to transfer lots from that adjoiner to the land that's going to be subdivided. No ifs, ands, or buts. There's no consideration where the adjoiner has road frontage. There's nothing in there, not one word that suggests that. B2 says, takes up our special situation, where we have a property that on a map is no longer adjoining. These two parcels do not touch each other. But they wrote the code to say we are not going to punish the landowner and have them lose their lot yield because technically on a map the parcels no longer touch each other. And if the reason they don't touch each other is because of a public road or a fee simple public utility easement, then if that's the reason they don't touch each other, they are nevertheless, for the purposes of transferring the lot yield, adjoining. It doesn't make any sense whatsoever to then say, oh, but because of the public utility strip, you can't have road frontage. Their logic completely defeats the entire purpose of B2. B2 there's no reason to even write it if you're not going to let them have the lots anyway, because the fee simple utility strip deprives you of road frontage. That's not the intent here. The intent is when it is separated from another tract, it was adjoining and now it isn't, you still get your lots. And it's just, again, it's just a calculation. It's adjoining, you're allowed to transfer it over, and then down the road, you've got to submit your plan. I mean, as everybody knows, Part 1, as we sit here today, Parcel 11, Part 1, is ineligible for subdivision. If you apply the same logic, it's ineligible because it doesn't have road frontage. Because you don't make up your mind on that issue until you actually get the site plan, and they show you where they had the fee simple access to the public road. That's when that comes into consideration. It does not come into consideration at this stage of the process. You can say, well, we figured they'll probably come up with a plan down the road that shows fee simple access. That doesn't make any sense. B2 tells us to disregard the utility easement. And it should be disregarded for all purposes even future obligations to meet a subdivision requirement. There's nothing in 155.033 in the calculation that says anything about all the myriad dozens and dozens of subdivision requirements. There's nothing there. And transferring it from a parcel that's been pulled apart doesn't say, oh, if it also has road frontage, then you can transfer it. It's just not there. They're reading words into it that aren't there. And we're asking you to apply logic. We're not trying to punish landowners because the strip went through. They still get their lot yield. The determination of whether property, the actual lots that are part of the subdivision process, have access to property is somewhere down the road. Part 3 is not going to be it's not going to be subdivided. Ever. Whether or not it has road frontage doesn't matter. That's not part of the property that needs road frontage. This is just a step of transferring the lots from Part 3 to Part 1. That's it. Part 1 down the road then has to show it has road frontage. That's the land that's going to be subdivided. That's the time to apply that analysis. Not now. And thank you very much for your time.
Ms. Moore.
Yes. Thank you, Mr. Chairman and Board, for your consideration of this matter today and your time. Further, as always, thank you, Mr. Webb, Mr. Staley, Mr. and Mrs. Gunzik, for appearing today. We appreciate the wheels of justice that occur. Before you today is a question of interpretation of the Carroll County Code of Ordinances and the matter in which they read. Section 155.033 is but a subset of 155 as a whole. The yield must exist per the regulations before it may be considered for transferring, and Chapter 155 should be viewed as a whole. Here, BGE owns the swath dividing parcel 11 in fee simple. When the deed was recorded granting BGE ownership over the swath dividing parcel 11 in 1968, the southern portion of the Gunzik's property became an independent parcel. Code language regarding this condition recognizes that each part of the property on either side of the fee simple strip are their own tracts. From a statutory standpoint, pursuant to Section 155.031, titled Subdivision Requirements, the property shall have a minimum of 30 feet in fee simple frontage to a publicly maintained road. Further, all lots being created through the subdivision process shall be designed to provide in fee simple frontage to a publicly maintained road, and the frontage shall be capable of providing vehicular access to the property. Interestingly enough, Chapter 155.033, as read in part, is titled Subdivision in the Agricultural District, and Section A is titled Lot Yield. Yet, Development Review assesses lot yield for agricultural properties of which this property is zoned for using the requirements outlined in Section 155.031, and the restriction on the number of lots outlined in 155.033, not simply based off of the size of the property, its yield, it is more encompassing than that. Therefore, Parcel 11, Part 3 does not meet the requirements, and as such, the decision made by the Bureau Chief of Development Review should be affirmed. Thank you.
Mr. Webb, do you have any follow-up on any rebuttal?
I waive rebuttal, thank you. I think you've heard it all enough.
Okay, the hearing and record of this case is now closed in accordance with the Open Meetings Act of Maryland. The board will now consider the case.
You go first, I'm not going first.
I'll go first.
Okay,
Yeah.
very good.
So I think the reason that road frontage keeps being referred to here is because it is the very first thing on 155.031. And putting the cart before the horse, before you get to 155.033, I believe is why we're here and what the issue is. To me, that parcel 11 could be denied entirely. You have options to have it not denied, that you could submit, and then they could make a decision based on that. I understand you want to transfer or borrow those lots from lot, parcel 11, lot 3, or parcel 3. But I see it that you had to meet the first thing first, and then you could move on to the second part. If there weren't options to show that, if there weren't options to move around that, I could understand how that would be very challenging for the property owner. But road frontage is the very first thing in 155.031. And that's why we're not referring to flood zones and everything else. We're referring to road frontage. So I agree with Development and Review's initial decision on this property.
Mr. Caldwell.
What a mess. Back to 1963, we have the original subdivision rules and regulations. This right-of-way by the BG&E came into place in 1968. So we're still in the Wild West phase of zoning and land development. The owner bought the property P10 and P177 in 1986. That's a total of 54 acres. Then in 2004 bought parcel 11, parts 1, 2, and 3 in 2004. One would assume that the owner did his due diligence when buying those lots and what restrictions were in place at that time, although the dates of when this part of the code was changed with the 30-foot frontage is up in the air. That's why I asked the question about that. When did that come along? And I appreciate Mr. Staley's input on that as far as he could tell. But it was still in place well before Mr. Gunzig bought the P11 property. Then the calculations took place, the changes in calculations have been there at least 12 years according to Ms. Matthias. So we've got 8 years of something going on in between. Over and above that, as Ms. Ford-Matt has said, the first step is 30 feet of road frontage, and then you go on to do your calculations. The other thing as well is there, and I asked a question about it, it says you must comply with all of the parts of the regulation. You can't just cherry pick bits and pieces to suit you, although it is interesting that they had this separate clause about the transference of lots, but it's very ambiguous. I have to go with, along with Ms. Ford-Matt in the decision that it's, with the owner having done his due diligence, he would know about these restrictions on the lots before purchasing it. And so therefore, I'm going to support the Development Review's decision. Thank you.
Ms. Eckert.
I disagree with my colleagues. I think that if the other parcel on this property in its entirety, as assembled for subdivision, was analyzed based as an adjoining parcel with regard to future potential road frontage, I think it clearly states in 155.033 that parcels that are divided by a public right-of-way, or the power lines, they are considered adjoining. So therefore, they also are adjoiners and should be considered in the calculation. I think that if that power line was not there, regardless of not whether they were compensated for the purchase of that easement, it's unlikely that they were compensated for development rights. They were probably paid as ag land when it happened. I think that the net result of this is this landowner is going to lose lot yield that would have been available if the power line easement hadn't gone through there. So I think the property owner is being punished unfairly because it's not being considered as an adjoining parcel.
Mr. Snyder.
No, I'm teasing. I've been very quiet, if you haven't noticed, which is really kind of unusual.
We did take note of that.
Thank you very much.
We were thankful.
And it's a very difficult case because I'm torn on both sides. I see the absolute rationale of the owner. Fact is, you know, let's do the density, you know, the Part B says you can do this and so forth and so on, and I also hear a review saying this is how we do business, this is our protocol, this is the review process, and it's there for a purpose. It certainly was an existing situation when the owner bought the property, but, you know, the reality is, I don't know what his plans were when he bought the property. You know, if he was just gonna, you know, use it for whatever, he looked at it from a development rights standpoint. What really helps me make my decision, as difficult as it may be, is, in this case, we're talking about 2 lots. I mean, it's kind of a smallish situation. But what happens if there's 500 acres on this side of the fence? Do we transfer 500 acres of density? And would that not change the character of how we, you know, the area? I mean, my point is, where's the line drawn? 2 lots or 6 lots or whatever the case may be. The fact is I find that staff has been consistent in the way they review things. They have review protocols they follow. And I would have to support staff's decision on this.
Are you done?
I'm finished.
What a case. I'm glad it was actually postponed a couple of months. These power easements give me heartburn. But as I look at this map, and I appreciate this map, the only thing that I would really like to have had was the lot yield, and I've done the approximate lot yield on these parcels. But as I look at this, and this, I mean, they just run that bad boy in a straight line. It created 3 parcels out of 1 parcel. And as I see it, the only way to utilize the lots on the other side of the power line, which wouldn't be subject to Senate Bill 236, would be to gain access to Wentz Road, which doesn't look like it's that far away from Wentz Road. It's a horrible situation that's been brought to our attention, and yet the very first thing that Development Review is to look at is the lot yield. And actually, Mr. Webb, I agree with you. A strict interpretation may have been that parcel 11, the lot yield shouldn't have even been considered at this point in the game until an internal road was demonstrated in concept plan. But they did allow that. But again, what's south of that power line, that can't be, there's no road access there. That's the rules in the zoning ordinance, and that's what Ms. Matthias has to go by. It's a very unfortunate situation based on the configuration of the lots and the power line as it goes through. Okay, board members, I'll entertain a motion.
So would the motion be to uphold?
Let's not uphold, let's just make a decision. You're making an original decision.
I don't know how to word I wouldn't know how to word the motion.
I could word one.
Word one, go ahead, you're good.
I'm gonna word mine.
Based on our discussions, we'll be here till sundown, getting a second.
Never mind.
Okay. I'm chair, I can't make a motion.
So help me with some wording. I'll be happy to make it.
Any suggestions, Mr. Colwell?
Oh, boy.
You're
Mr. Motion.
No, you missed a motion. Jeez. Let's see now.
Make it easy, go ahead and do it.
okay. Do we uphold?
Yes, go ahead.
All right, so in case number 6527 before the Board of Zoning Appeals, that the board deny the request for transfer of lots from the parcel P11 303. Does that work?
No, just uphold it.
Oh, just uphold? Okay, so scrap that one. All right, so that the, in case number 6527 before the Board of Zoning Appeals, that the board uphold the decision made by Development Review regarding...
I'm so sorry, this is 6528, just so the record is correct.
I'm sorry?
This is 6528.
says-
6527 was the ag pres from a month ago.
My sheet of paper says 6527 on it.
The agenda says 6528.
All right, sorry. Well, piece of paper I have is incorrect. Try again, third time lucky, perhaps. In case number 6528, before the Board of Zoning Appeals, that the board uphold the decision made by Development Review regarding a decision in the pre-submittal stage.
Second.
Okay, it's been moved and second. Any further discussion? Any discussion?
Kind of, leaning both ways on this. I think there's still a gap somewhere in the records that's where this came in. And
There's a lot of power lines about to go through this county. And
you know what?
I think that's,
I'm gonna change my view to,
Well, you can't because you made,
Yeah.
well, we'd have to vote down your motion then, because you made the motion.
oh, wow, okay.
I think,
And again, there's another option. They can go and show how they can get that road frontage. And
only,
We'll have the ability to do that right now.
Yeah.
We don't have to direct them, they have the ability to do that.
how are they gonna get road frontage if they don't believe that that power line
That's not the case before us.
is an adjoining property? Makes it an adjoining property. How are they gonna get that, how are
So
they
did
gonna
we
get
have a
that?
second to that motion?
You.
you
Okay,
seconded.
so are we, so if you're gonna change your mind,
I can vote no if I want.
you can vote no, so your thing, okay.
It doesn't affect the
That's
motion.
true, you're absolutely right, go ahead.
So we had a,
Okay, any
had a
further-
motion, had a
any-
second.
We got a motion and a second.
Doesn't change
Any
the
further
outcome.
discussion?
Doesn't, unfortunately.
Okay, all those in favor, aye?
Aye.
Aye. All opposed? Motion carries. Our oral decision will become final upon a written decision which will be issued within 30 days unless otherwise extended by the board. The board's decision may be appealed by filing a petition for judicial review with the clerk of the circuit court for Carroll County in accordance with the provisions of Chapter 200, Title 7 of the Maryland Rules of Procedure. The appeal must be filed within 30 days of the date of the board's written decision. Thank you very much. Hearing is adjourned.